All right, welcome to Peace of Mind Radio. I am Brian Ramsey along with Isaac LaFond and Eric Douglas. And today we're talking asset titling and beneficiaries. So I will tell you, this is one that we did a radio show on this, I don't know, it's probably been 2 years ago. And we actually got quite a few calls on this one because we're going to talk about things that maybe you hadn't thought about. And I will tell you that the reason I mentioned this to the guys to do this week is I had a client in last week, and they said to me, hey, I just added my daughter to my checking account. Of course, I went, all right, time out. Maybe we need some education here. So anyway, before we get to that, anything you guys want to add before we get to this? Anything you guys have had any issues with asset titling and beneficiaries? Any kind of cool stories? I've got one to tell you before we get started, but
I mean, just a general comment that I think that people don't focus enough on this. You know, they kind of open accounts and they have accumulated some accounts and policies and that, and they have beneficiaries done. Normally, the beneficiaries aren't even correct, but a lot of times the way that they title accounts is for sure is they don't understand the tax implications or liability implications with that.
Yeah, I'm not sure how many cool stories I have, but definitely have some horror stories.
Yeah,
and some of those can come out as we're having the discussion. I'm quite sure, but yeah, this is extremely important to make sure that you're constantly reviewing these things on a pretty regular basis, at least annually.
Yeah. So this is one of my favorite stories. I'll tell you before we kind of get into all this. This has been years and years ago. We were asked to settle an estate I was part of a team that was asked to settle an estate. And y'all probably heard me tell this story, but it was a physician. And he was a fairly prominent physician in town, and most people would probably know his name if I said it. But anyway, he had passed away. He was married and had a couple kids, and so they all kind of scattered everywhere. And the surviving spouse just didn't want to deal with. She was obviously grieving and just said, hey, will you guys help us sell the estate? And so we were hired to do that. So I was part of that team. And we were going through some old records, and we found an old whole life policy that he had when he first got out of med school. And sure enough, he was married, and then he got out and he started making, right when he first got out of school and he started his career, he got divorced from his original wife, or his first wife, and then he married. And he had a full life with his second wife, and y'all know where this is going. But sure enough, we pulled up this old policy, and we called, and they said, it's not current wife, it was wife number one. And so we had the pleasure of calling up wife number one and going, hey, guess what? You just won the lottery. And we said, you do have the right to disclaim, to disclaim it, and it would go back to the family. And she was like, here's my address. That's literally what she said. Here's my address. It's pretty funny. All right, so that's kind of what we're talking about today is it's just making sure that that assets are titled properly, that beneficiaries, that you're reviewing those on a regular basis. Because literally, when you have a beneficiary on account, that's who gets it. It doesn't matter what your will says or what your trust says. Doesn't matter anything. Had nothing to do with your estate documents. It's all about who's listed as a beneficiary. So, with that being said, what is the list of accounts? There's a whole slew of accounts that typically, when somebody opens it, you're automatically listing a beneficiary. What are some of those accounts?
Well, certainly your retirement accounts, the most common are the ones you're going to open at work, right? Your 401ks, your 403bs, your TSP plans if you're a government employee, et cetera. Whenever you open those accounts, you're obviously going to be prompted to name a beneficiary at the time. If you're really young, and it might even be your parents or somebody like that if you're not even married yet. But usually your wife, and if you have kids, you might add them as contingent beneficiaries as well.
Yep, obviously insurance policies,
that's
a big one. Any of that kind of stuff, anything that has money attached to it, normally requires a beneficiary. And we can get into later, I'm sure, all the different ways you can structure the beneficiaries on your policies.
Yep, we're for sure going to talk about that. All right, so when you have, and by the way, let me say that we're going to get into this in a few minutes. There are also accounts that we all open checking, savings, traditional brokerage accounts or non-retirement accounts. Those type of accounts typically don't come with beneficiary designations, right? When you open them, they don't say who's your beneficiary. But we're going to talk about this in a few minutes. It's incredibly important to name beneficiaries on there. And this is where I think when you go to a bank, the banks make a huge mistake by not informing customers about this. So we'll talk about that in a few minutes. All right. How often do you guys recommend clients review beneficiaries?
At least once a year. The major caveat to that, though, however, is going to be major life events. Deaths, divorces, obviously being the two big ones, marriages, etc. You always want to make sure that you are going back and not even waiting until an annual review to update the titling on all of your assets. Because when we talk about horror stories, I know one in particular that we had a client. It actually happened before they became a client of ours, but the grandparents passed away. They intended to leave all the money to the son. The son was in the middle of a nasty divorce at the time that the grandparents or his parents passed away, and so all the money that they left to their son, the soon-to-be ex-wife was now entitled to half. And that was absolutely not what the wishes were of the clients that passed away, and the son ended up becoming a client of ours later on down the line. But he had that horror story. There's all kinds of stories out there like that. I mean, you see it with celebrities and millionaires and people that you would think that know better. You always hear about these fights in court over multi-million-dollar estates for celebrities after they pass away, and that's because they didn't have all of their affairs in order prior to them passing away.
Yeah.
Yeah, I know. I mean, our standard procedure with any of our planning clients, Brian, you designed our kind of review process, which is, that first meeting, first third of the year.
Yep.
We typically with our clients 3 times a year, and you specifically build in that first meeting that we're going to make sure if we hadn't caught it in the middle of the year, to Eric's point, when something came up, ideally you would change it quickly.
Right.
But if it wasn't caught before then or wasn't disclosed before then, we'll catch it at
Yep.
that meeting because it's built into the agenda every year that we're going to talk about that.
And I'll tell you, I've been doing that for I couldn't tell you how many years. First meeting of the year, we do beneficiary designation review. And it's amazing. I have not once, in all these years I've been doing it, it's been north of 10 years, I've never had anybody go, why do we do this every year? I've never once had that. As a matter of fact, I've had folks that have been working with other advisors, and they come here and they go, my advisor not once ever had this conversation outside of when we set up the meetings. Yeah. Mm-hmm. But we do it every year. All right, let's see. Okay. Let's talk. I want to talk for a second about the accounts that we mentioned a minute ago, accounts that typically don't have beneficiaries. What are some of the accounts you typically, that someone might own that don't have a beneficiary designation assigned to it?
Well, you mentioned bank accounts before, so things like your checking account, savings accounts, CDs. You mentioned actually banks, really pretty much any account that you would open up at a bank for the most part. To your point earlier, banks don't do a fantastic job of making sure that they're designating a beneficiary or something, somewhere that account can transfer on death to.
Yep.
So generally speaking, most accounts that you're going to open up at your bank are going to not have a beneficiary titled on the asset.
Yep.
Yeah, real estate would be the other
Exactly.
big one. Yeah,
Yep.
And so thinking there's ways around it, but that requires a legal document and some planning on people's part to have property transfer efficiently and tax efficiently and all that. But yeah, real estate's the other big one.
Yeah, real estate's probably, wouldn't you guys agree? Real estate is probably the most difficult asset that you own that's to plan for transfer-wise. When you guys agree? Because you can't just do it unless you go through advanced estate planning when you have trust documents. And we're going to get to that because even titling of real estate, again, this is another one that, excuse me, I've been here 17 years. I've been in the business 17 years. And I have not run into anybody yet that owns real estate the right, well, I take that back. I got one other guy. But he owns like a gazillion real estate. It's like LCL or LLC owns trust, owns LLC. I mean, it's so complicated. But anyway, just your normal investor. if they own a piece of, like 1 or 2 or 3, 4 pieces of real estate, or maybe a second home, they just don't own it properly.
The guy's using it as a side hobby or a side hustle, something like that.
Or even a second home, they just don't own it properly. And until you explain to them, they're like, oh, I didn't know I was supposed to own it like that.
Yeah. I was talking to one of our younger clients, and he's a sharp guy, engineer, and he said, we were doing a standard review this summer, and I, was catching up, seeing how things were going, and he said, yeah, I'm excited about to buy my first investment property. And I was like, okay, that's exciting. We need to talk about this. Are you planning on one? Are you going to accumulate several? Is this like a big part of what you want to build wealth? Because I agree. It is a good way. It's a good, with investments and retirement, it's a good way to do that. But I was like, you need to go talk to this accountant.
Right.
You need to talk about what kind of property, and he'll explain to you how you might want to think about structuring that as a business, and think about that, right? And how you would title the first, because you don't want to just buy it and then try to redo it later and pay additional fees. And then I was like, you need to also go talk to some people I know that do this and have several properties, so they can explain to you what it's like, what's life like with 5 investment properties in Louisville, Kentucky. Yeah. And there's just a lot more to your point that goes into it. But the nice thing is when you have someone coordinating with you on a regular basis, that got talked about on the front before he ever did anything. And, it'll be set up the right way now, from the jump.
Yeah. All right. So let's just stick to that point, because I know I had real estate a little bit later in the agenda, but let's just stick to that point. So when it comes to real estate, let's stick to your primary residence for a second. Okay. So typically what we find is, in the majority of cases, right, we find where your primary residence is typically owned either individually, so if you're not married, or if you're joint, you own it with your spouse, right? Mm-hmm. Now, what's the issue with that? It doesn't accomplish one thing that we typically always find that clients want to do, which is a probate avoidance, right? That's the biggest issue, right? Just it doesn't do anything for you. Mm-hmm. So what do we do? Typically, we have a conversation with a client around. Again, this is asset titling. So if a client says, hey, I want to avoid probate, I want to do everything we can to avoid probate, what is one of the solutions or strategies that we have a conversation with clients around to help them get that primary residence, not talking other real estate, but primary residence, out of probate?
Open a trust.
That's right. Yeah, trust planning, right?
Create a trust. Own a trust. And it's not nearly as complicated as most people assume it to be. Most people think, especially like kind of your mass affluent clients, which makes up a bulk of our, client base, of course. But your mass affluent clients think, oh, those are only for like the wealthy, the rich people, the generational, where you're handing out millions and millions of dollars. That's not true. Trusts are very, very functional, and they're also quite affordable if you structure them the right way. You don't have to do anything super fancy if you can just, put together kind of a basic testamentary or revocable trust. That's going to do wonders for an estate plan as far as making sure that you're able to avoid probate and everything goes where it's supposed to go.
Yeah, and I think we'll have, and maybe this is a good follow-up show to this, is talking about trust planning, because you guys know I'm a slight advocate for trust planning. I only browbeat clients.
Nobody gets more excited.
See, he's joking about this. We've seen this though. I mean, he literally
it's onslaught when it comes to me and trust planning. But I see the benefits behind it, and as you guys will hear if you watch next week's show, and we talk about trust planning, you're going to hear me tell stories that I've been on the other side. I've been on the trust administration side where we've distributed assets out of a trust, and maybe this is my personal experience. I have no idea, but I just have not seen that go very well when there's no trust in place, or there's a trust in place that says, yeah, hey, here's a $2 million estate, and a kid turns 25 and give him a third of the assets. I can tell you right now, I've not, again, may just be me, and maybe it's Kentucky or in Louisville, I don't know, but I just not seen that go very well. So,
the other big one is with farms.
Yeah.
Like how the just some nightmare stories with the way farms get, people don't talk about the stuff. The parent or the grandparent doesn't want to talk about it with the kids. There's infighting, all this stuff, so they just leave it alone. And then, then you end up like parceling out, and there's probate, and it's just not good for, we were on a call yesterday morning.
I was going to say, yeah.
And one of our consultants, she brought up how farms in Kentucky have slowly been, basically parceled out to where now they're not even functional.
Right.
Farms are not at scale and not where they were originally intended when someone first bought the property, for enough acreage to actually do something. So trust planning with farming families is really, really important.
Yeah, sure. Okay, so let's go to owning real estate that is let's talk about secondary property. Okay. So we've got, when you guys are working with clients and, we've taken care of the primary resident. We know we're going to own that inside of a trust or have a trust own the property. But now let's talk about second home. So we have a lot of clients that own second homes, right? They either own them in Florida or it's probably the most common is in Florida.
Lake houses.
Yeah, lake house. Yeah, there's tons of lakes around here. Yep. So how do you guys encourage clients to own secondary homes?
So that's been one of my, when we do get into legacy planning with people, you kind of think about, you actually have them functionally think about how they're going to leave money and how it's going to be structured. And really a trust is kind of the only way to have a nuanced way that happens. And so I'll give you an example. So we had an older lady, health was great. She's in her early 80s. And she just doesn't, she had enough pensions and stuff that she just was a pretty frugal person. She had all these assets. Her kids were doing well, so she didn't want to just leave them a pile of money after she's gone. She wanted to find something she could do today that would be cool. Well, they love going to lakes and all that. So I encouraged her. She originally thought, we'll just all chip in together. Like the couple daughters and me will go in equally on this. And I was like, okay. I was like, let me just so we walked through what that might look like after she's gone and how that would work and all these things. Right. I said, wouldn't it be cool though? Because you have this money that you have no purpose for. Maybe you set up a trust and the trust owns the lake house, then all the family then owns the lake house, and then they all get rights to it, and that's a generational thing. You can put enough money to buy the house, set enough money in an account, basically permanently endow the care of, keeping the property in good condition, doing all this stuff. Then it's something forever that this family gets, and that was just really cool. She had never thought about doing it that way. But then when you explain it, and it's like, again, she was like, Derek's point, that's not for me. I don't do trusts. Right. She is in her mind, I'm not worth enough to need a trust.
Get that all the time. Yeah, sure. Yeah, I will say that the one scenario I run into a lot, and this goes back to my point in the very beginning of the show, we're talking about real estate when I said that we don't think, in my experience, that we don't run into a lot of folks that own outside their primary residence when they own other assets is not titled properly. So I will tell you that a lot of folks we run into that own, let's say, a second home in Florida. Let's just use that example. Typically what we find is they own it, they've gone down there and they said, well, we'll just own it. We'll just, buy it, and they own it individually. Well, there's a couple of issues there. Number one, the biggest issue is when you own, and you have to know this, when you own real estate in multiple states, if it's not titled properly, you have to probate a state in every state that you own real estate. So in this case, if you owned a home here in Louisville and you owned a home in Destin, which is South Louisville, people in Louisville find that funny. If you're not from Louisville, you wouldn't think that's funny.
I laugh because that applies to my family as well.
Yeah, so. Everybody, the whole city of Louisville goes south to Destin for spring break if you're not from here. So anyway, it's almost like you never really get away from Louisville during spring break. But anyway, so what happens is you own a house here in Louisville, you own a home in Destin, for example, and if you were to pass away, then your estate is probated here and in Florida. That's the issue. But if you own it properly, then you can avoid it. So how do we do that? Number one is we own it inside of an LLC. So use a limited liability corporation, have that LLC own the property, and we do that for a couple of reasons. Number one, for risk management purposes, right? So you're not there all the time, so you can't be there to make sure nobody gets on your property and does something stupid and gets hurt or whatever. So that's really a risk management tactic, right? But also, we know people that sometimes will rent their property to other family members or friends or
Yeah.
whatever, and you just want to make sure you protect yourself. That's it. So and there's others, and we'll do another show someday on why the best use of limited liability corporations. But so anyway, we're going to have the LLC own that piece of property, okay? But what happens there? If you individually own the LLC, guess what? It still doesn't avoid probate, right? So we still have the probate issue. How do you get around probate issue? Is the LLC or your trust owns the LLC. Okay. Now I will tell you, that's how I'm a real estate investor. I own real estate, and that's how we're set up. As a matter of fact, I own the real estate with my father and my mother and my sister. And if you see our ownership, it's really jacked up because we have an LLC, and then we have 3 trusts that own the LLC. But that's the way to do it. Right, because we're avoiding probate and we're minimizing our risk owning assets inside of an LLC. So I will tell you that that's one that, boy, when people own real estate, they just don't get the titling right, and it just subjects them to risk, either through liability risk or through probate risk, right?
Well, I think it's just a little bit of a different mindset you have to take when you're talking about rental real estate, because you need to view it as a business. Not a side hustle, not a hobby, not something you do on the weekends. Oh, this is going to be fun. I'm going to go fix up a house and, you flip it or, find a renter, whatever. You need to treat it like a business. And how would you pass down a business to your kids or to the next generation?
Right.
That's the mindset that you need to have when you're titling assets like these, specifically real estate.
Yeah. Yeah, cool. So that's enough about real estate. I could probably go on and on about that. And by the way, if you ever want to get into flipping houses and you want to hear a horror story, call me. I'll be happy to share mine, because they all don't go as they do on TV. I can attest to that.
It usually takes longer than half an hour to flip them, right?
It usually takes a long. Yeah, exactly. Yeah, and you just got to know what you're doing. I got in a little over my skis. As a matter of fact, when they say sometimes you get in over your skis. You guys ever heard that term?
Yeah, sure.
Yeah, I not only got over my skis, I flipped around several times. But anyway, that's a whole different story. Okay, let's change gears a little bit, and let's talk about. And I want to stay on the topic of assets that we typically own that don't have a set designated beneficiary. Okay, let's stay in that, because we know IRAs and Roth IRAs and 401ks, 403bs, all that, they have beneficiaries. We talked about that. Let's talk about checking and savings accounts. Okay, so here's the huge mistake that banks make, and the reason that banks make a huge mistake is when somebody walks in the door and they say, I want to open up a checking account. The first thing they should do is say, do you want to add a beneficiary to your account? They don't ever do that, right? Because A, they don't get paid for it, and 2, it's extra piece of paperwork, and all they care about is the next checking account, the next CD, the next deposit. That's all they care about. So they really don't take the time to get to know, and they can't, because you're a retail and it's just a transaction. It's a quick transaction at that. But that's where we come in, right?
Yeah.
When we do full balance sheet focus, we're looking at risk assessment, we're looking at probate avoidance, and checking and savings is a huge one. So, client comes in, you're doing a full balance sheet review. Isaac, I'll throw this one at you. So, client comes in, full balance sheet review, checking and savings accounts. Client comes in, you say, hey, let's talk about your checking and savings. And the client says, older client, we'll say, okay? Oh, sorry, a more mature client. And the client says, the example I put in earlier this week, earlier in the show, but it happened earlier this week. Client comes in and says, I just put my daughter on my checking account. Why would they do that? Why do they typically want to do that?
I mean, typically they're doing it in case something happens, then their daughter, who would be usually they are assigning their family member that would be taking care of their stuff when they're gone, right? So the logic is good intentions, where they're like, yeah, well, if something happens to me, I want her to be able to access my account. I don't want it locked out and nobody can pay for anything after I'm gone, right? Cover funeral costs or any other ancillary expenses. I want her to have access to that. So that's the thought process.
Yeah.
There.
Or in the case that they become incapacitated.
Correct.
Right.
Yeah. They're the power. They got power of attorney, and they've set up the documents that way. So they're just like, I'll just put her on the account.
Yeah.
And it's been suggested at the bank when I've been there, like with my dad doing stuff.
Yeah.
And I'm like, no.
Yeah. You don't know what you're talking about,
Yeah,
Mr. Miss Banker.
I'm like, it's cool. I got it.
Know your audience, right?
Yeah, that's right.
Yeah. But that's to answer your question, that's why they're doing it. Yeah.
Yeah, well, for sure. Absolutely. So this lady that was in the other day, and Eric, here, come, I'll throw one at you. So she came in the other day, exactly what Isaac just described. She said, hey, she actually she came in to talk about her estate plan, just to kind of review it. Uh-huh. And we had done this maybe 5 or 6 years ago, and really nothing had changed for her. Okay, so she didn't need to make any changes, but the one thing she said, which I told her 5 years ago not to do this, but she did it anyway. She said, hey, I took my daughter to the bank the other day, and I just added her on to my account, and I basically said, okay, time out, refresh, we're going to walk back through this. So why would you tell somebody to not add a client or not add their child to their account?
Well, if you add someone else to your account, they have access to that account just like you do, and so if it can become anyway their own personal piggy bank. So it's someone. If you are going to add someone in that capacity, one, you need to make sure you have the absolute utmost trust in that person that they're not going to abuse you, take advantage of you, take liberties with that specific account that they now have access, 100% full access to. The cases where it makes sense, and you mentioned this point earlier, is when someone's incapacitated, someone with dementia, Alzheimer's, they're some type of health issue, whatever it may be.
Yep.
When someone needs to access that money on their behalf in their lifetime, and you mentioned a POA, that's a good way to do that. But in most cases, and it sounds like this person was not incapacitated, still had full capabilities. All their faculties were still with them. There's no reason to do that. They could just add them as a beneficiary, set that account up as a transfer on death, a TOD, make that a TOD account. So that way, if something were to happen to her, immediately that access moves over to her daughter, it sounds like in this case, to cover things like funeral expenses, end-of-life expenses, things like that.
Yeah. The other thing is the liability.
Exactly.
Liability, So if her daughter got in a car wreck, even if she wasn't doing anything with bad intentions, right, that now is on her daughter. It has to put that on her balance sheet. So if someone goes after her daughter's assets, that account can be, could be leveraged in a lawsuit and that kind of thing. So that would be the really way, even if that daughter would never steal from her or anything like that, that's probably not likely. But the problem would be her daughter may not be doing anything wrong. Some life event happens, health issue, right? Bills pile up. They have claim against anything with their daughter's assets.
Yeah. But let's just refresh, because this is one that we see all the time, and I want to make sure we're crystal clear on this. So if you're kind of catching us midstream or something in this podcast, I just want to make sure we're crystal clear. So we're talking about checking and savings accounts at the bank.
Yep.
Right? And what we're talking about is the two typical, and we're going to talk about solution in just a second, but the two typical reasons why a parent or someone would add a child, or it's not even a child, it's anybody, right?
These are grown adults.
Yeah, it's
40, 50 years old.
Yeah, exactly. Yeah, exactly. But we're not talking about husband and wife or anything like that. That's not what we're talking about. We're talking about typically a single parent, right? Because they've had a spouse that's passed away. So it's either mom or dad, or it's the only surviving parent, has named a child or wants to name a child as a beneficiary. And we're saying don't do that. Reason number one is because what Eric said, they have full access to their account. They can walk into the bank and clean out that bank account, and there is zero you can do about it. Can't do anything. Number two is the liability reasons. If your child were to go out and make a mistake, like Eric said, that is subject to any litigation matter. So with that being said, so I would say that number one, clients do it because they want the continuation of someone to have ability to be able to go into that account and keep the lights on. If they become incapacitated, or if they pass away, they want to. It's a probate avoidance tactic, right? And so they say, well, if I put a daughter on there, then it goes direct. She'll just have the account and it doesn't have to go through probate and so on. So how do we solve that problem? Let's take them one at a time. So in the event you become incapacitated, how do we solve the issue around making sure someone can continue to pay the bills out of that checking account.
Setting up a POA, power of attorney.
Exactly. Power of attorney, super simple and easy, right?
Mm-hmm. Very easy.
That document is not expensive.
No.
That is not an expensive document at all.
No. And I will tell you that set up the right way, when a parent becomes incapacitated and you take that POA into the bank, as long as it's recently done, I will tell you there's some issues with older power of attorneys, so just make sure you get an updated one. I think the end of 2018, the state of Kentucky implemented a phrase in the powers of attorney that says that the bank can't reject it as long as it's signed and witnessed and all that and notarized. Then they can't reject it. They have been rejecting older ones.
Okay.
But so just keep that in mind. But as long as you have an updated one, you can walk into the bank, show them the power of attorney, and you can continue on as normal. So that's number one. All right. Now, in the event of a passing, how do we make sure that money that's in a checking and savings account gets to where you want them to go? How do we do that? You mentioned a minute ago, Eric. Take that one.
Well, yeah, well, just setting up a transfer on death account. Just essentially, you're adding a beneficiary to the accounts, but you're titling the asset as a TOD account, transfer on death.
Yeah, and so when you walk into your bank, you don't need to know that it's either a TOD or a POD. So TOD is transfer on death. A POD is payable on death. They're used interchangeably. Depends on the institution. Mm-hmm. You don't even have to know that term. You can just walk in and say, I want to add a beneficiary. They'll know that's what you're doing is putting a TOD or a POD provision on it. And don't think that's only suitable for individual accounts. You can do it as a joint account. So if it's husband and wife and you put a beneficiary on there, please note, I get this question on a regular basis. Well, does that mean, if my spouse dies, my kids get the money? No, it doesn't mean that. Your surviving spouse, it's still their account if it's joint.
Yeah.
That doesn't matter. It's only at the passing of the surviving spouse does the money then transfer.
Both parents have to get to end of plan,
Right. Yeah, they have to. Yeah, that's exactly right. That's exactly
It's
right.
a very polite way of
End of plan. You both
Saying that.
came to end of plan.
Yeah.
Yeah.
All right. So we've I've got one other piece that I want to cover, and then anything else you guys want to cover too. So one of the things that we talked about was owning real estate. And we talked about using a trust to own real estate. And we talk about this all the time, right? We say, hey, typically that's we're going to own the trust inside of a revocable trust where you still own the property, but you're doing it through your trust, which essentially is just you because it's your tax ID that owns it. And we do that for probate reasons, right? And we do it. I don't know what I just said. It is early, but I just said something. Maybe I'm sorry if you thought I said something else, but I didn't mean.
No, it was fine. But we should camp here for like one more minute because it's going really well.
I do have these squirrel moments, as you know. Anyway, so we talk about owning real estate inside of a trust. So we're talking about revocable trust, right? And what we mean, and the reason why you use a revocable trust is so that. Who knows? You may change your mind, right? Mm-hmm. Or you may want to sell that piece of property, or you may want to do something else with it. So you have the ability to do that. So the other way that you can own property, okay, is through an irrevocable trust. And we do, and this is getting into more advanced estate planning, but I want to bring it up because we do have clients that are getting a little older, right? Or more mature, and we have that conversation around using a trust to own real estate. And I want to talk about, just for a quick minute, is the difference between owning real estate inside of a revocable trust versus owning real estate inside of an irrevocable trust. And let's just briefly talk about why, the benefits behind the two. And that'll lead, I think, to another show when we talk about more advanced estate planning. Okay? So the first thing we've already talked about, so I don't want to rehash it all, but when you own your primary residence or something like that, and you're young like we are, I don't know, 50, it's still young. Anyway.
It's the new 40, right?
The new 30. It's all right. No, when you're younger and you have a family and that kind of thing, you would own it inside a revocable trust. So that, if I want to go sell my house, I just go sell my house, right? Now, when you get more mature, and I'll say my parents are in that category, we have had conversations around how they own property. And because they're getting more advanced in life, there are reasons that you might want to use an irrevocable trust to own your real estate. And it's more about asset protection than anything else. That's kind of the strategy that we talk about. So when you go see an attorney and you're younger like we are and you start talking about trust, you're typically talking about a revocable trust.
Yeah. You
But
don't know what's coming down. You got 50 more years till end of plan. So
Absolutely.
you need to have some flexibility.
Yeah. Well, and you don't have, well, yeah, that's right. But so for example, my kids, which you bring up an interesting point. So when you have assets that are titled the way my parents are, and my parents are almost 80, okay? And they're listening to this show, so they're super young, but anyway. But when you own real estate, when you get a little bit older, you're more in asset protection mode, and there's lots of reasons behind why you'd want to do that. But when you do that and you own it irrevocably, you're essentially telling your kids what? You own the property, right? You're the trustee. I no longer have access or no longer have ownership to it. I have a living interest, meaning I can live in the property and my kids can't kick me out. But you do that for all kinds of different reasons. Again, mainly for asset protection. But if you're more mature and you go see an attorney and you are trying to protect assets for medical expenses and all that stuff down the road, you might have a conversation around owning a piece of property irrevocably. I just want to get that out there because we're seeing more and more of it. I know the three of us are huge, or in our firm is huge advocates of it, but and not very many firms will ever have a conversation with you around owning assets inside of an irrevocable trust. One, because it's very complicated. Not that many people know much about it, so they just avoid the conversation altogether. And that's just not something we do. We know about it. We're pretty proficient at it. And we love to have those conversations, and we understand the benefit behind them. So if you want to know about that, let us know. But I just throw that out there because I want to make sure that everybody knows that it can either be revocable or irrevocable. So
Probably the easiest way to explain it is when you have an irrevocable trust, you can't change the terms. You are, in essence, whatever is underneath the banner, the umbrella of the irrevocable trust. You are essentially removing from your estate. You're giving up essentially ownership to your point. So you talked about that you're giving up ownership rights. You may still have the depending upon the way it's built, you might still be able to live in the house, for example. But you are essentially removing that asset from your estate if you are moving it into an irrevocable trust. The irrevocable trust is its own tax-paying entity. It's its own person, for lack of a better term.
Yeah, it is. Yeah. So one other thing, and then again, I'll let you. I feel like I'm dominating this one, but anyway,
I know. I don't want to take any conversation trust related away from you because you get so excited.
I know. It's an obsession. Anyway, the one thing we failed to mention earlier is if you own your house today, right, and you want to transfer that to your trust, it's pretty simple and easy to do, right? Mm-hmm. Anybody know how we do it? So quick deed.
You go for it.
Quick deed, right? You quick deed it.
Quick claim deed. Yeah.
Maybe throwing them a curveball there. It's early in the morning. No, you do it through a quick deed. It's super simple and easy. It's like any attorney will do it for $100 or less. Super easy. And the question you're going to get when it comes to quick deeding a property from your individual name into your trust name, especially if you have a mortgage, which almost everybody that we talk to, that we encourage to do this, has a mortgage. When you do, there is zero issue with transferring a piece of property out of your individual name into your revocable, not irrevocable, totally different story, a little bit more complicated, but into a revocable trust. There's no issue with the bank. You just have to call them up and tell them, hey, it's not titled in my name, it's titled in the trust name. And half the time, they don't even change it.
Yeah.
Because you're still on the hook. Your Social Security number is the one obligated to make that mortgage payment. You could literally transfer the piece of property to your neighbor and say, you own this house, but you're still obligated to make the mortgage payment. So I just want to make sure that's kind of a clear point.
Yeah, absolutely.
Yeah. All right. Anything else you guys want to cover on asset titling or beneficiaries?
No, I think another episode we definitely we should cover, maybe here in the next couple, we'll talk about non-retirement investment accounts. Yeah. How those accounts are owned and how they're meant to be transferred and thought about from a planning perspective is a really important way, because most couples will just do a joint account without thinking really about how that transfers and the taxes on it. I think that would be a really good episode. But I mean, we definitely unpacked a lot. We don't want to overwhelm you guys with this. And plus, Brian might just he's going to wake up here soon, with the morning podcast.
That's
He's
right.
going to get real excited if we keep going. So
That's very true. But we're not talking. We won't be talking about trust plan. Oh, we might be talking about trust plan if we do that one.
probably will.
Yeah. Okay. I'll be involved in that one then.
I have a feeling you could probably weave that one into whatever discussion that
Trust
we're
planning
having.
for everything.
Yeah.
Yeah.
Even buying a car. You gonna buy a car? Put it in your trust. No, I'm kidding. Anyway, all right. So listen. So next week we'll tackle another topic next week. And if you didn't catch the past couple of weeks, just make sure you go back and watch the last couple of shows. We've had some really good shows, and we'll do that in the future. And Eric always says,
Listen, subscribe, rate, and review. If
There
you're
you
watching
go.
on our YouTube channel, make sure you click that little subscribe button. Give us a thumbs up. If you're listening on Apple, make sure you leave us a review, a rating as well. That'd be fantastic. We really appreciate your support.
Yeah.
yeah, and just make sure that if you want to listen to the shows, just go back and go to our any podcast channel or YouTube channel, whatever. We have them all listed there. Isaac does a great job putting them all together, and putting music to it and all that good stuff. So just make sure you go back and watch it. And the other thing is, if you have a topic that you want us to cover, just shoot us a quick email. Right,
Yeah.
it's right there. Leave us a message and say, "Hey, I'd like for you guys to research and do a show on this particular topic." We always like when listeners give us an idea. So
I think if you haven't even noticed a theme yet, most of our show topics come from a discussion we had with a client maybe like the previous
absolutely.
week.
Yeah, that's what this one came from.
Yeah.
Right.
Absolutely. Absolutely.
All right.
All our stuff's right there. So to Brian's point, if you want a live conversation, we're happy to talk to you. We even have coffee here.
We do.
Got a comfy couch. So if you've got something you want to unpack or you want to suggest an episode idea, just let us know. All our contact information is right there on the screen.
Thanks for listening. Have a good week.
Appreciate it. The information given herein is taken from sources at IFP Advisors, LLC, doing business as Independent Financial Partners, IFP, IFP Securities, doing business as IFP, and its advisors believed to be reliable, but it is not guaranteed by us as to accuracy or completeness. This is for informational purposes only, and in no event should be construed as an offer to sell or solicitation of an offer to buy any securities or products. Please consult your tax and/or legal advisor before implementing any tax and/or legal related strategies mentioned in this publication, as IFP does not provide tax and/or legal advice. Opinions expressed are subject to change without notice and do not take into account the particular investment objectives, financial situation, or needs of individual investors. This report may not be reproduced, distributed, or published by any person for any purpose without IFP's express prior written consent. Securities offered through IFP Securities, LLC, doing business as Independent Financial Partners, IFP, member of FINRA and SIPC. Investment advice offered through IFP Advisors, doing business as IFP, a registered investment advisor. IFP and Family Wealth Planning Partners are not affiliated. The information given herein is taken from sources that IFP Advisors, LLC, doing business as IFP, IFP Securities, LLC, doing business as IFP, and its advisors believed to be reliable, but it is not guaranteed by us as to accuracy or completeness. This is for informational purposes only, and in no event should be construed as an offer to sell or solicitation of an offer to buy any securities or products. Please consult your tax and/or legal advisor before implementing any tax and/or legal related strategies mentioned in this publication, as IFP does not provide tax and/or legal advice. Opinions expressed are subject to change without notice and do not take into account the particular investment objectives, financial situation, or needs of individual investors.